shooting. 14-49.46 makes it clear that a sports shooting range that has been in operation for at least 3 years cannot be regulated by way of a noise ordinance or a zoning ordinance, or a nuisance ordinance. So there's a number of things you look at. Number one, as far as whether or not the noise ordinance applies to a particular range, there are a number of things you look at. Number one, has the range been in existence and been operating for at least 3 years? And secondly, is it a sports shooting range as defined by the ordinance? As I said, the definition begins an area designed and operated for the use of rifles. In my estimation, when I've researched this and construing and constructing statutes the way that I've been trained to do, designed and operated means a commercial enterprise. Operated means a commercial enterprise. Designed means a commercial enterprise. A can set up in the backyard would not be designed as a shooting range. But if it is a legitimate sports shooting range and it's been in existence for more than 3 years, this noise ordinance would not apply to it, and no prosecution could be had.
Okay, thank you. Any questions on that for the rest of the board? I know one time I was listening to the radio and I heard that wouldn't be able to have turkey shoots. Well, as I understand, to get a turkey shoot in this county, you have to go see our planning director. He goes out and inspects the site and gives a letter, whether it meets zoning and there's some safety issues and things like that. Now, I'll have to bet my bottom dollar that he's not going to give one to somebody that wants to set one up in their backyard. Would you, Mr. Gray? I didn't think so. Especially in a subdivision.
That's right.
All right. Mr. Mills, you have anything, you wrote this ordinance, do you have anything that you want to clarify on the ordinance? You know, I think a lot of people dismiss the whole first section, which talks about unreasonably loud or disturbing noise. Maybe you, because it became clear to me that some people hadn't read the ordinance, so maybe you would like to go over that, or if you have a statement on what process you went through or something.
I would like to make a few remarks, Mr. Chairman, and I agree with you. It appears from the emails that I have read that many people either have not read the ordinance or they have overlooked the primary parts of the ordinance. And it appears to me that many of the concerns that have been raised dealt with section 12-3311. 12-33 is the part of the revised ordinance that deals with the exceptions to the proposed noise ordinance. Okay, so I can read it. And subsection 11 is noise from the discharge of a firearm or firearms when the firearm is being used to take birds or animals pursuant to NC General Statute, Chapter 113, Subchapter 4, or when lawfully used in defense of personal property, or when used pursuant to lawful directions of law enforcement officers. What that provision does is it makes clear the ordinance does not regulate the discharge of firearms when used in those three circumstances. The emails that I have received, many of them, take the position that what it means is that those are the only 3 times when one can discharge a firearm in Johnston County. Absolutely not true. Those are simply 3. No, it's not what it says. No, it isn't.
That's what the police are going to enforce.
What about target practice? That's not part of
Will
it.
you let him finish?
My grandkids how to hunt. What about a well-maintained militia?
Hey,
Oh, jeez, man, why?
Second Amendment. Isn't it?
I thought we were going to be respectful and proper in this thing, but if
We're trying to take care of ourselves.
well, I understand it says, he just read it to you, that you can have protection of property. You can kill coyotes, you can kill snakes, you can kill a rat in the backyard, whatever you need to do protecting your property.
That is absolutely not what it says. It says that those are 3 instances where the ordinance does not apply. Why? because North Carolina state law says that that the discharge of firearms cannot be regulated in those 3 instances. That does not mean you cannot fire a gun, and nowhere in this ordinance as it's written does it say that one cannot fire a gun. Nowhere in this ordinance does it say that those are the only 3 situations in which you can fire a gun. Absolutely nowhere in this ordinance does it say that. What it says is that you cannot fire a weapon which creates an unreasonably loud and disturbing noise as defined by the ordinance.
Point of
Now,
order. Isn't it true that some of the statute is already on the books?
now,
This is not an open public hearing, and if we keep getting hollering out there, I'll have the deputies remove the ones that are interfering with this process. Go ahead.
thank you, Mr. Chairman. Many people interpret this exception to mean that they can only discharge a weapon in one of these 3 instances. As I said, this is not the case. These are simply 3 instances in which the ordinance does not apply. One thing must be made clear. All this ordinance does is treat the discharge of a firearm like any other noise. The discharge of a firearm in and of itself does not constitute a violation. If a noise, any noise, is unreasonably loud or disturbing, then and only then is it a violation. In determining whether the sound is unreasonably loud and disturbing, a judge or a jury must consider those factors stated in the ordinance, such as the time of day, how close the noise is to the residences, whether the noise is recurrent, repetitive, intermittent, or constant, the volume and intensity of the noise, whether it is enhanced in any way, whether the noise is compatible with the surrounding area, and so on. If a neighbor plays his music so loud, so constantly, so repetitively, and so inconsistently with the nature of the surroundings, such that the music is an unreasonably loud and disturbing noise, I would think that everyone would agree that firing a weapon in an equally intense manner would also be an unreasonably loud and disturbing noise. Several comments have been made about the unbridled discretion placed in the hands of the sheriff to determine if a noise is unreasonably loud and disturbing. This is a misunderstanding of how the laws operate in North Carolina. When charges are brought, the judge or jury, not the sheriff, must determine beyond a reasonable doubt that the noise created, whether from a firearm or some other source, constitutes an unreasonably loud and disturbing noise as defined by the ordinance. By amending the ordinance to provide definitions and factors to be considered, the ordinance is made more clear, therefore more enforceable. The purpose of this ordinance, as I have drafted it, as I've attempted to draft it, is not to infringe on the rights of any citizen. It was written to protect a person's right to lawfully fire weapons, while at the same time respecting and protecting the rights of all citizens to the quiet enjoyment of their homes. Thank you, Mr. Chairman.
Thank you. There's, a lot of what you said, and that's in the first part of this ordinance. Just because you hear a gunshot doesn't mean it's against this noise, it's a violation. Just because you hear a loud Harley with straight pipes going down the street, or a kid with a loud music in his car going down the street, you hear it all a minute or half a minute or something, doesn't mean it's a violation. It has to be, but if it's up under your window with the guy revving his Harley every morning at 6:30, or somebody playing their music in the subdivision and you hear it as soon as you turn into the subdivision, then it might be a problem.
Correct.
So it is proximity, the length of it, the duration, and where it is. So I think a lot of that was missed and everybody jumped towards it. And like I said, there was a lot of misinformation out there. And I appreciate your comments. Does anyone else have anything to say?
Yeah, Mr. Chairman, if I may, please. For those in the halls, Devan Barber, you can't see me. I appreciate what everybody's saying. I appreciate what the attorney's saying. The bottom line on this whole situation is very simply this. The attempt here was not to deal with any change to the firearms ordinance for the discharge of firearms by anybody responsible and reasonable. This was supposed to be a noise ordinance. The way it's written, there is reference to discharge of firearms in here, which can be misconstrued and read in a lot of different ways. So what I would suggest is that we adopt the noise. First of all, also I'd like to remind everybody that the discharge of a firearm is only one of many situations we're having right now with noise and nuisance. And some of them are very bad, and they consist of a lot of other things, a lot of music issues and those type of things. So we're dealing with a noise situation more than we're dealing, in our minds, with a discharge of a firearm issue. So what I would move that we do is we strike, we adopt this noise ordinance, and we strike in section 6 in its entirety, which refers to discharge of a firearm. I have spoken with a lot of folks in the firearms community that I respect, and people with gun shops, and they all think that this should clarify the position that what we're dealing with is noise. I would also like to point out that simply by striking this does not mean that you can't still violate the noise ordinance with a gun. I mean, you go up and sit under somebody's kitchen window and let loose with a clip out of an AR-15, but you can, it's disturbing the peace. And I think everybody in here that shoots, because, you know, I know most of us shoot, understands the differences when you're doing something stupid and when you're being considerate. So hopefully that this would clarify that and remove the terminology in here that refers to discharge of a firearm, which can be construed as saying, if I shoot my gun on my property, it can be a violation of the noise ordinance. That is not the intent, never was the intent. That's the reason it never, we got caught by surprise with all the emails, because it was just not anything that we ever really thought or were intended to do. Most of us, like I say, shoot, and we have respect for that. So I hopefully, in my conversations that I've had, and those of you out here, that are a bunch of you here that I've spoken with, know and seem to think that have read this thing, that should clarify it. So I would move that we adopt the noise ordinance, strike the section 6, which refers to the discharge of a firearm. We still leave in the definitions for, you know, for the unreasonably loud and that kind of thing, and adopt it
Mr. Chairman, for the record, I think he's referring to, Commissioner Barber's referring to section 1232, subsection D6.
That is correct.
D6.
D6. Discharge of firearm or firearms in such a manner to create an unreasonably loud and disturbing noise as defined in conflict. There's no distance requirements here. This is simply just noise. We're not putting distance requirements in. This is not the firearms ordinance, and we're not, I hope, going there. Yeah, but please, I think I clarified that. If somebody in a subdivision sitting 65, 70 feet from somebody else's house shoots 3,000 rounds, you know, it will constitute a noise ordinance violation. And it should. Okay.
We have a motion. Any discussion on that motion? Hearing none, all in favor, aye?
Aye.
All opposed, like sign? Unanimous. All right, we're done with the noise ordinance, and unless y'all want to stay around for the reason